Novartis AG and another, and Teva UK Ltd and others.
Yes, Ms. May.
My Lord, good morning. My Lord, I appear on behalf of the claimants together with my learned friends Mr Edwards and Mr Justice. My Lord has Mr Hinchliffe here on behalf of the first, second and seventh defendants. Mr Mitchison is here.
Who are they? Which one's Teva?
So Teva is D1,
Right.
D2 is Dr Reddy's,
Yes, I
and
see.
D7 is Beatrice.
Right.
And then Mr Mitchison is here for Denmark, that's D3, and Mr Duncan is here for Zentiva, D4.
Right. Thank you.
My Lord, we're grateful for the opportunity to appear before my Lord this morning. The structure of my submissions are as follows. Firstly, I'm going to address my Lord on the grounds of appeal and explain why they have a real prospect of success. Secondly, I'm going to address my Lord on the other compelling reasons why we say this appeal should be heard. My Lord, the grounds of appeal are in the core bundle at tab 2, and they are addressed substantively in our skeleton, which is in tab 3.
Yep.
My Lord, since time is limited, I propose to focus on the first 4 grounds, as grounds 5 and 6 relate to obiter comments on the balance of convenience, and of course will primarily be engaged if we find ourselves before a substantive court on the appeal.
I wouldn't make that assumption, Ms. May.
No, of course I'm not making any assumptions, but that's why I focused on grounds 1 to 4 to start off with.
Okay.
My Lord...
Just to be clear what I meant by that,
yes.
I think you have to be able to win on what you're calling the obiter thing, as well as on the bit that you're calling the not obiter thing, to get permission to appeal. I just want to make clear to you that now, so that you don't labour under a misapprehension.
Thank you, my Lord. I'm grateful for that indication, in which case I will make sure I address my Lord on all grounds.
Yeah.
My Lord, starting with ground 1, the failure to conclude that there was a price spiral. My Lord, as the authorities make clear, whether or not there will be a price spiral in any particular case is a question of fact. But once a price spiral is likely to occur, the risk of unquantifiable damage to the patentee is made out. In this case, there was clear evidence that a price spiral was likely, and perhaps I can just show my Lord very quickly that evidence. It was bundle C1. C1 tab 3, page 39. This is the first statement of Ms Bride, and it's paragraph 77.
Right.
And it's in the middle of the paragraph where she, if we pick it up in the third sentence, in summary, if the defendants or any of them launch their fingolimod products on the market, I expect them to do so at a price that is significantly lower than the price of Gilenya in order to make their products more attractive than purchasing Gilenya. As explained above, generics are able to sell their products at lower prices. The defendants are also likely to undercut one another in price to try and maximise the volume of their business, whether inside or outside the scope of a tender setting. She gives similar evidence in the same statement on the next page, at paragraph 81 to 82. Perhaps I could just ask my Lord to read paragraph 81, please.
Sorry, in the same witness statement?
Yes, I'm so sorry, same witness statement. Page 40, paragraph 81.
Right.
And then again at 82, bottom half of the paragraph, if we pick it up sort of about 6 lines before the end, the presence of up to 13 companies beside Novartis competing for the fingolimod market is likely to lead to companies undercutting each other in price to try and secure and gain as much of the market as possible, for example, by entering lower bids. It's not clear how quickly or how fast sales of Gilenya would decline over this period. What is clear is after the tenders were put in place, and most likely before, sales of Gilenya would be massively reduced. And we see similar evidence in her second statement, which is C1 tab 5, paragraph 11, which is bundle page 57. could just ask my lord to read that, please.
Just a moment. Yeah. So page 57, paragraph which?
11.
11. Right.
And then again over the page at paragraph 16. So just pausing there, what my lord's seen across those paragraphs is firstly evidence that the pre-tender sales are likely to be discounted to about 50% or more. Evidence that the tender sales price could be as low as 5% of the monopoly price. Evidence that the generics are likely to undercut each other when it comes to the question of price. And that's reinforced by the statement of Mr. O'Toole for Zentiva, and that's in bundle D5, tab 1, page 14. Oh, sorry, page 4, sorry, I can't read my own note. And it's paragraph, the section is paragraph 14 through 17. The most important paragraph is 15, where he makes clear in that paragraph that the price per unit that Zentiva is likely to sell fingolimod will change and develop over time. It's usual for the price to start higher and decrease as time goes on. But this is not a linear process. It's dependent on a number of factors, such as the availability of the product. And what's particularly odd in this case is that the judge accepted the evidence that the generics would sell at a much lower price, hence his finding of a marked price depression, but nevertheless went on to hold that there would not be a price spiral. We see that in the judgment at paragraph 50, which we have set out in our skeleton.
No, I mean, I have actually read the materials.
Yes, thank you, my lord. And we've got four criticisms.
What do you say the spiral? Why is the spiral unquantifiable? What is it about the spiral that you are so keen on, if I can put it that way? It's important to you to say that the judge erred, but I'm trying to understand why it matters.
Yes, so the reason it matters is, firstly, first and foremost, the impact of the marked price reduction in period 1 has a knock-on consequence to the ability or inability to quantify damage in period 2. My lord is with me in terms of the shorthand of period 1 and period 2, I hope.
Well, I think so.
Yeah, period 1 being the interim period between now and trial, and period 2 being period post-trial to patent expiry. And we say that was a fundamental error on the part of the judge in terms of his inability to appreciate the importance of the impact of the marked price depression in period 1 on the unquantifiable nature of the damage in period 2.
Right. Well, I understand that. Well, what the judge decided, as I understand it, is he took the view that he accepted your point that the prices would drop markedly, so a lot.
Yes.
In, let's call it period 1.
Yes.
But he also rejected your evidence, didn't accept it, that if the market was restored, monopoly was restored, the price couldn't go back. Now, the latter point, I understand, is very important to the point you've just made to me as to the knock-on effect of whatever happens in period 1 to period 2. That's a different ground of your appeal. What I'm still struggling with at the moment is what's magic about the spiral that bears on the issue we're currently discussing.
Well, as my lord sees from paragraph 50 of the judge's judgment, he tried to distinguish this case from the line of authority which he was aware of, the line of authority being that when there is a price spiral, that is when the patentee is able to make out the risk of unquantifiable damage. And you see he's trying to distinguish this case from that line of authority in paragraph 50 of his judgment. But we say that that attempt to distinguish is an error of principle. And it's an error of principle because once the judge had held that there was going to be a marked price depression, as we say he was right to do, it just wasn't open to him to hold up that there wouldn't be a price spiral. And that's because a marked price depression is the end result of a price spiral. The only difference being that with a spiral, you may have a gradual reduction in price, whereby each reduction is prompted or stimulated by the reduction that precedes it. Whereas when you have a marked reduction, you effectively get the wholesale fall off the cliff edge in price in one go. So we say there is a complete gap in the logic here in terms of the judge's reasoning. It's completely inconsistent to accept that there's a price depression on the one hand and yet try to distinguish this case from the cases where the court talks in terms of a price spiral, but the outcome of a spiral or a marked price depression is the same. And in that line of cases where there is a marked price spiral or marked price depression, the court accepts that damages cannot be adequately quantified. And so,
hang on, I don't know, I'm lost. If a spiral is the same thing as price depression,
yes,
then the only question is whether that's quantifiable or not. But you're trying to say that it's a matter of authority that spirals are unquantifiable, which doesn't sound very convincing, I have to tell you, Ms. May. It's not a matter of authority, it's all about facts, isn't it?
what I'm saying is, in paragraph 50, he started off by making a finding, which we say was correct, that there was a marked price depression.
Yeah.
And that comes from the evidence I've shown you. In the very same paragraphs where he accepted the evidence that there was a marked price depression, where Ms. Bride also talks about a price spiral, he rejects the evidence of a price spiral. We say it's inconsistent for him to accept one point and not the other.
No, but I'm trying to understand what you say the difference between them is.
Well, in truth, there's no difference because...
Well, there is a difference, though, isn't there? Because you say, for some magic reason which I haven't understood, if you can ping the word spiral, then suddenly it's automatically unquantifiable. And I'm struggling to understand why it's unquantifiable on the way you're putting the argument. Because, as I understand it, what the judge decided was he agreed the price would drop in the first period, but he held it would go back again if you won. And therefore, he said, the time between now and the trial is quite short. Yes, the prices will drop, but when the market's restored, you'll be able to go back to where you were, and there's a period of time where we'll be able to quantify the loss pretty well. Not a perfect remedy, but adequate. And I'm struggling to understand why that's wrong, other than by getting into a discussion about spirals as if they have some magic associated with them, which I don't understand.
My Lord is right that there is no magic in the word spiral as distinct from a price depression. All I'm trying to answer is the way in which the judge presented his reasoning in paragraph 50. He made a distinction between a price depression and a price spiral. And we say that distinction was wrong.
Right, but you say that's because spirals are unquantifiable. And he was clearly disagreeing that whatever was going to happen in the first period was the cause of unquantifiable harm, which is no doubt why he decided to do what he did in that paragraph, because he was obviously of the view, as I've just put to you. Isn't that fair?
No, I mean a spiral, the point of the spiral, as I say, is that it leads to a marked price reduction.
Right.
And that price reduction has a knock-on consequence to the ability to quantify damage across the...
I agree that the question, seems to me, which is sort of what I'm maybe not hinting at very clearly, is knock-on consequence. Isn't that what really matters?
It is an important part of what matters,
Okay.
and as my lord has
I'm not
observed.
trying to confine your submissions, May. I'm just putting to you what strikes me as you're making them.
I'm sorry, I didn't hear my lord.
Doesn't matter. I mean, sorry, just to repeat myself, and forgive me for repeating myself.
Yes.
As far as I understand it, and I don't think I'm saying anything controversial here, what the judge decided was, given that it's a speedy trial in October of this year, yes, he said the generics entering the market would mean that there was marked depression of the price, but he said, rejecting your evidence to the contrary, if you won the trial, your clients would be able to sell again at a monopoly price, which means that the long-term effect that you're talking about wouldn't happen. Isn't that what he did? I mean, I'm not trying to be unfair about a summary of it.
Well, perhaps I can move on to my second ground. I'm
Okay.
conscious that time before my lord is
Yes.
short, and of course each of our grounds are independent.
Right.
The second ground was the failure to take into account the likely tender prices.
Right.
There was clear evidence before the judge that the tender prices offered by the generics could be as low as 5% of the monopoly price. I've shown my lord one paragraph, but it's also repeated in Miss Bride's second statement. That's C1, tab 5,
Sure.
page 58. And this is where she explains the figure that she puts in her first statement more clearly. It's paragraph 17. And she explains that it comes from what's been going on in relation to sales by Milan in Italy. And that's the basis upon which she gives the evidence that the tender price could be as low as 5% of the monopoly price.
Yeah.
It's fair to say that the generics provided different evidence. Their evidence was that the prices in the tender are fixed, and therefore there's no spiral. We don't need to turn to it, but I obviously need to draw it to my lord's attention.
Yes, no, I got that.
To be fair, but we say that misses the point, because the point isn't that the prices are fixed, but that they're fixed at a significantly lower price than that of Gilenya.
Right.
There was also evidence from one of the defendants, that Dr. Reddy's, to the effect that on their side, they said generics would be more cautious and they wouldn't necessarily lower the price to that level.
Right.
But we say that evidence ignores the clear evidence from both sides that the tenders are blind, and so effectively a generic only has one shot to bid a sufficiently competitive price in order to win the tender. And there was also clear evidence that each generic gets feedback on the tender they offer, and that has a knock-on consequence in terms of how low they bid the price for the next tender. Just for my lord's note, that's in Mr O'Toole's statement at paragraph 30 and 33. That's D5, tab 1, page 6.
Makes sense.
And we say that the judge erred by failing to have regard to all of that evidence, holding instead, as he did at paragraph 51, that the tender price did not matter. And we say that was an error of principle, firstly because the judge ignored the relevant evidence. He couldn't possibly resolve the conflicting evidence of what the tender price was likely to be, and so he had to accept that there was a likelihood that the tender prices could be as low as 5% of the monopoly price.
Right.
Secondly, and relatedly, we said that the judge erred by failing to appreciate the impact of that evidence in terms of the inability of Novartis to restore prices in period 2.
Right.
And it's obviously ties in with points we've already been discussing this morning, in terms of the relationship between the price suppression in period 1 and the importance of that price suppression in period 2. And we say that was something that the judge failed to appreciate or understand.
Okay.
That then leads on to my third ground, which was an error of principle in evaluating the evidence in relation to the ability of Novartis to be able to restore the price of Gilenya after trial. And that was dealt with by the judge in his judgment at paragraph 53, and it was in our substantive skeleton at paragraph 39.
Right.
And what we say is the error of principle here is that the judge applied the wrong standard or the wrong test in terms of his evaluation of this evidence.
Right.
Because what he held was that he did not accept it should be assumed that the NHS will nonetheless refuse to pay the monopoly price at which Gilenya has previously been sold. But that's the wrong standard, because Novartis didn't need to show that the NHS will refuse to pay the monopoly price. All they needed to demonstrate on the evidence is that there is a realistic prospect that the NHS may not pay the monopoly price. And we get that, we explain this in the skeleton at 40 to 42. And we refer the court to the Leo and Sandoz decision. We set out the relevant paragraphs in the skeleton at paragraph 41. And what's clear from that authority is that there's a distinction on the one hand between a possibility which is fanciful and a possibility which is more than fanciful and thereby realistic. And the error of principle on the part of the judge in this paragraph 53 is that he didn't apply that standard, but instead imposed upon Novartis a higher standard, which was effectively having to prove that the NHS will nonetheless refuse to pay. In fact, the evidence before the court to the effect that it was likely that the NHS would not be willing to engage with Novartis at full monopoly prices was realistic and not fanciful. Particularly bearing in mind, as my lord has already seen, the evidence was that generics could cut the list price by as much as 95%. And in paragraph 53 of the judge's judgment, he gives two reasons for rejecting Ms Bride's evidence to the effect that she thought it was likely that it would be difficult for Novartis to re-establish full sales at full price.
Yeah.
The first reason he gave was the distinction that he had already drawn out in his judgment in a number of places prior to paragraph 53, to the effect that this is a secondary care product, a product that's distributed through hospitals, rather than the more familiar primary care product distributed through pharmacies and wholesalers, which appears in most cases. But as we point out in our skeleton, that distinction doesn't make any difference to the application of the principles and the analysis before the court. I think that's made clear in the Novartis Hospira decision, with which my lord is familiar. My lord will remember that was a secondary care product.
Okay.
And the analysis...
Isn't the significance of the secondary care, though, that the point the judge makes in 53, that these are very sophisticated purchases?
Right, which comes on to that's his second observation,
okay,
that the NHS are sophisticated purchases.
Well, the first one is, of course, there's no drug tariff effect, which is one of the effects one sees in these cases sometimes.
Right.
And he's right about that, isn't he?
He is,
okay.
No doubt.
And then the second point about the secondary care, at least as I understand it, the point that's being made is that these are sophisticated purchases.
Yes, but of course neither of those points remove the likelihood that it will be difficult to restore monopoly prices. Right. Quite the contrary, we say. It's precisely because the NHS are sophisticated purchasers that they are going to do everything they can to resist higher prices.
Right.
And so the reasons that the judge gives in his paragraph 53 are not reasons at all.
Okay.
There's certainly not sufficient reasons to justify rejecting Ms Bryde's evidence by reference to the relevant standard. So in a nutshell, firstly, he applied the wrong standard, and secondly, the reasons he gave to justify his rejection by reference to the wrong standard are not reasons which stack up.
Okay.
And we say that's a fundamental error of principle. Next, ground 4. The judge erred in principle by failing to appreciate the impact of the uncertainties in the ability to, in period 2, on the ability to quantify damage, or inability, as we say, to quantify damage. So as my lord has seen, the judge held at paragraph 61 that the level of sales of Gilenya in period 2 can't be predicted, and he was right to do that. But we say he erred in principle because he failed to appreciate the impact of that uncertainty in terms of the inability to quantify resulting damage to Novartis.
Right. So which paragraph are you referring to?
Of my skeleton or of the judgment?
No, the judgment, sorry.
61.
61, I'm sorry. I know you said it, I just forgot. Yes, thank you. Yeah. Yeah.
So since there is a realistic prospect that Novartis will not be able to reinstate full sales at monopoly prices, damage in period 2 is necessarily going to be unquantifiable because there's no certainty as to how much Gilenya would have been sold in that period in the counterfactual. We say, to borrow the language of Lord Justice Jacob and Leon Sandoz, damage to Novartis goes beyond the merely difficult to being incalculable. In the same paragraph, the judge seems to have considered that it was necessary to show that the uncertainty in period 2 is caused by generic entry. But that's not correct on the authorities. And we refer, my lord, to Teva and Activists, which is in the bundle of authorities, but actually the relevant paragraph is set out in our skeleton at paragraph 44. So it's our skeleton paragraph 44. Core bundle, page 31, and if my lord looks at, in particular, at paragraph 33, my lord sees that it's legitimate for the court to take into account the uncertainty in the market, including other factors which might impact on it, such as alternatives to the infringing product becoming available.
Yes. Doubt it's a matter of authority, but anyway.
So that we say that was a further error of principle on the part of the judge because he considered that if he seemed to think that the unquantifiable nature of the damage in period 2 was independent of generic entry, and that was a reason to ignore it. Whereas in truth, the uncertainty in period 2, which it will be caused by a range of factors, including generic entry, leads to a complete inability on the part of the court to assess in the counterfactual what damage Novartis will suffer if the injunction isn't granted now.
Right.
I mean, as we go on and explain in our skeleton at paragraph 56 and 57, even if the judge is right and it's necessary to show that the future uncertainty in the market is attributable solely to generic entry, there was evidence that the lower price of generic fingolimod could impact on the price of the other DMTs in the market and their perceived relative cost effectiveness, which in turn would affect the market share that each DMT, including Gilenya, would achieve.
Right.
That just reinforces, we say, why it's impossible to raise prices back to the monopoly prices. We also note that the judge took an inconsistent approach on uncertainty caused by market competition, because back at paragraph 51 of his judgment, he observes that it will be open to the generics to argue in the counterfactual that if fingolimod was only available at the full monopoly price, then the NHS may switch to other DMTs instead. But in the context of Novartis case on unquantifiable damage, at paragraph 58, he rejected the same idea that generic entry could affect whether patients were prescribed other DMTs instead.
That reminds me, presumably the guidance in the Patents Court guide about involving the NHS in these applications was complied with?
Yes.
And they're not here?
No.
Okay.
Our next ground is balance of convenience.
Yes.
And we obviously recognise that the comments of the judge made in relation to that issue were over the comments.
Right.
Because he didn't, because he'd found that damage to Novartis was quantifiable,
Right.
he didn't go on and decide the question of the balance of convenience.
Right.
But he did obviously make some observations.
I mean, the difficult. Can I just? I don't want to hide it from you, Ms. May.
Yeah, no.
The problem I have with the reason I encourage you, as you are doing, to look at those other grounds of appeal is because at the end, the judgment isn't just a judgment that says damages to the patentee are quantifiable, therefore no injunction. It also says at paragraph 71, in case I'm wrong about that, I'll look at the rest of cyanamide, and he goes through it all and concludes at the very end that overall, least risk of irremediable prejudice comes down against you. And that's a conclusion which it follows from what the judge has done. So it seems to me that's a conclusion which at the moment it's not clear to me on what basis you're saying he was not entitled to reach that view.
Well, we see.
Given, in particular, sorry, I didn't mean to wait till you started and then interrupt you, I'm so sorry. Given the points I've been putting to you, that as he saw it, the market could be restored after trial if you win.
Yeah. So in relation to the point about the market being restored after trial if we win, even if the monopoly price could be restored in period 2, we still have a case of unquantifiable damage. And that's because of this inherent uncertainty in the market in period 2 and the relationship that Gilenya has in that market vis-a-vis the other DMTs. So take the scenario where a patient is on fingolimod. They've been receiving Gilenya, there's generic entry, they get given the generic product instead. Then after trial, assuming Novartis prevail at trial and the generics are withdrawn from the market, at that point it's perfectly feasible that a patient will undergo a patient review.
Right.
And at that point it will be open to the doctor to consider what is the appropriate medication to prescribe to that patient.
Right.
And the review is prompted by the generic entry and the change in the market conditions by generics being on and then coming off. And at that point, the relative cost effectiveness of Gilenya relative to the other DMTs in the market is going to be a point of consideration as part of the process of deciding what the patient is going to be prescribed instead of generic fingolimod, which is no longer available. Right. And as a consequence, there's a risk in the counterfactual, regardless of the price of Gilenya. In fact, a fortiori, if the price of Gilenya is in fact re-established to its monopoly price, that by virtue of the generic activity, a patient is going to be prescribed a different medication to Gilenya in period 2 in the counterfactual.
Right.
And make no bones about it, these are definitely arguments which will be pursued by the generics if we find ourselves on a damages inquiry following a successful patent infringement trial.
Right. I don't understand why that matters.
Well, because it matters because the generics can't have their cake and eat it, in the sense of they can't suggest to my lord that these questions of uncertainty and unpredictability in relation to period 2 are irrelevant for the here and now, and yet rely on those issues for the purposes of trying to reduce a damages claim following a successful finding of infringement at trial.
Okay. What about Arrow? It's right, isn't it, that you, I assume, that because I've been told this, that the point that the Arrow jurisdiction was available as an antidote to the argument about divisionals and clearing the way, that wasn't the point that was put to the judge, is that right?
Well, I'm not sure that's quite fair, because Teva had issued their own claim in advance of the Novartis claim, and that claim sought an Arrow declaration.
Yes.
And so there was a party before the judge who was seeking an Arrow declaration.
Right.
And so it was...
That wasn't my question, was made. My question was about what points were put to the judge, and as Mr Hinchcliffe's note says,
yes,
that you didn't suggest, or neither did he, no doubt, but then that's the point, is it's on your side, that the availability of Arrow relief, which is a point you've taken in your skeleton as an antidote to the point made in paragraph 79 of the judgment,
yes,
and he says that that point wasn't put to the judge. And that sounds like the way you answer my question means that that's correct. That's all I was trying to find out.
yes. I confess I can't remember, and I haven't checked the transcript.
Okay.
I'm sorry.
Thank you. That's fine.
But it may be that those in front or behind me can tell me the answer. So, my lord, in relation to ground 5, we say that the first error that the judge made in this part of his judgment was failing to have regard to the status quo and the counsel of prudence, which is to preserve
That's ground
the status
6
quo.
then, but I may be wrong.
I'm sorry?
I think that was ground 6.
Yes, I'm so sorry.
That's all right. I'm just making sure I'm keeping track. Yes.
Sorry, I'm doing it by reference to our skeleton. You're absolutely right. Yes, I'm sorry. Let's deal with ground 5 first. So in relation to ground 5, we say that he was wrong to take into account the fact that the patent application was a divisional. I mean, there was simply no evidence to support the view that there was anything by way of inappropriate conduct by the part of the patentee in the form of repeated divisional filings and amendments to prolong the patenting process. Quite the opposite, my lord. Novartis had filed a divisional in the normal way, and that had been filed in 2015, and my lord has seen the history of how it is that it's taken us until 2022 to get a patent grant. And the key problem in the journey was nothing to do with Novartis filing the divisional. It was to do with the decision of the OD assessing the application as being lacking in novelty. And that was a decision which was overturned by the TBA and is not pursued by any of the parties in their grounds of invalidity in the substantive proceedings in this court.
Okay.
And there was no evidence that there was a practice of repeated divisional filings, to use the word of the judge, by Novartis in relation to this patent.
This is the second. There was a parent, then there was a divisional, and this is the second one.
Right, but there was no evidence that my lord is right, but there was no evidence that it was being done for some malicious
That's a slightly different point.
reason.
I mean,
And as we say, it was an error of principle on the part of the judge to take that into account, not least because divisionals are an inherent and legitimate part of the European patent system. And it's not something which we say as a matter of principle should count against a patentee, when all they've done is legitimately deploy the legal framework that's available to them. So then, as regards balance of convenience, my lord has seen what we say in our skeleton.
Yep.
I mean, this is a straightforward case of maintaining the status quo. The generic fingolimod products are not on the market, and the trial is in October.
Yep.
And it's the Council of Prudence to maintain that status quo and grant the injunction pending trial. And in that context, we say that the judge erred in not assessing the relative size of the damage to the claimant relative to the defendants. And there are a number of cases where the court has taken that into account. And my lord, I'm sorry?
Such as?
It's in our skeleton at paragraph 64.
Second. Oh yes, okay. Thank you.
And that's not the only one.
That'll do, that's fine. You've got one. I'm not trying to encourage you to add more. But
Sorry, there are others. But for the purposes of this submission, one is good enough because it's a Court of Appeal authority.
engraved on my heart, that one.
Yes, indeed, I can imagine it is. So, conscious of time, my lord, can I address my lord on other compelling reasons?
Sure. Was that in your grounds of appeal?
Yes, unless...
Okay. I missed it. My fault, no doubt. Anyway, go on.
My lord, we have three compelling reasons why we say this appeal should be heard. First, we say it's appropriate in order to give clarity to the standard that should be applied in the assessment of the likelihood of damage and also the impact of uncertainty on the quantification of damage. Secondly, because the Supreme Court has recently recognised in the Interim case the desirability to review the approach to American cyanamide more generally. And thirdly, because this case raises a novel point of law about the ability to obtain interim relief in respect of a patent application. And as we understand it, that will be a point that will be raised by way of a respondent's notice.
Sorry, say that one again.
Well, as my lord has seen from the judgment, this case raises a novel point of law.
Oh, yes, sorry, yes, the
Yeah.
point about the pre-grant injunction. That's what you mean. Yeah.
So we say those are three compelling reasons, in addition to the prospects of success of the grounds, to bring this case before the Court of Appeal.
So just on the Supreme Court point, can I just
Yes.
make sure I've understood, because it's in your skeleton at 78, and
Yes.
I remember, I had forgotten it, and I remember it now. This is, you say the Supreme Court expressed an interest.
Yes.
There isn't a reference for that. Is that because this was something that was said on some application of permission to appeal, which ultimately failed?
I don't know if it's in the authorities bundle, but I've seen it. So the Supreme Court issued their decision in Interim, refusing permission to appeal, but only on the basis that there was insufficient time to hear the appeal before the trial. This is my lord. Just to rewind, my lord will recall in Interim there have been two sets of proceedings between Interim and Milan.
Yes.
So in the first set of proceedings, in relation to the original interim injunction application before Marcus Smith.
Mm-hmm.
That went on appeal, and then it went to the Supreme Court.
I see.
And the Supreme Court expressed an interest and recorded in their reasons that it was of that they had an interest in considering the American cyanamide test and whether it was appropriate to adhere so rigidly to the 4 steps of the American cyanamide test, but that because of the time, the shortness of time between the application for permission to the Supreme Court and the substantive trial, there was insufficient time to resolve the appeal.
Right.
And so for that reason, they refused permission.
Right. How is
And
that
I
going to
do,
help? I mean, given that, it sounds like this is exactly the same, so I'm not seeing at the moment how that's going to help you.
well, because I don't consider there's insufficient time to resolve the appeal between now and the trial.
Well, I can understand that there is, I'm getting my knots the wrong way around.
Yes.
There's enough time between now and trial for the Court of Appeal to hear an expedited appeal.
Yes.
That I follow. But that's not the question. Because the Court of Appeal isn't in a position to review American cyanamide.
No, that's fair. That's fair.
So I'm struggling to see why this isn't in the same situation as New York.
I take my Lord's point, and I suppose I pray it in aid because it's an indication that the question of applying the principles for the purposes of this application is a question that's appropriate, needs to be considered by the Court of Appeal.
Okay.
But perhaps the most compelling reason of the 3 is the novel point of law that comes in the context of this case specifically.
All right.
I've been given a reference to where Ms. Lane discussed arrow relief on day 1 of the hearing. She said that Teva had brought proceedings for arrow declaration, which was in place of clearing the way. That's at page 28, line 2. But it's not in the bundle.
Okay.
Can I just have a moment, please, Madam?
Of course.
It's just one point where I may have misled the court, for which I apologise.
Don't worry.
It's in relation to my Lord's question about the NHS.
Right.
We have not told the NHS about this hearing.
Oh, right. Well, that wasn't what I was asking.
But we have told them about
You did tell
everything
them
else.
about the previous one.
So they are beneficiaries under the cross undertaking, and so they obviously know about the action and the litigation, and indeed my Lord might have seen from the papers as a consequence of their understanding of what's going on, they have halted the Welsh tender.
Yes. Right. No, I got that, but I hadn't completed the thought that it meant they must have known because it doesn't matter. That's fine. Thank you.
So, my Lord, unless I can help my Lord any
No,
further.
that's very helpful, Ms. May. Thank you very much. Yes. Who wants to say something? The stage.
My Lord, obviously our overall submission is that you should refuse permission to appeal. And as we explained in the notes, the decision of a judge to grant or refuse interim relief is an exercise of discretion. And as this court made clear in the Elan Digital case, there's a heavy burden on a party seeking to appeal such a decision to show that the judge has either erred in principle or has exercised his discretion in a way that no reasonable judge could have done so. And when you look at the grounds of appeal, it's plain that this appeal is fundamentally one against the judge's findings fact. And we say that this court should be very wary about getting involved in considering such those kind of conclusions. Now, before I go into the grounds of appeal, it's important to keep in mind, and I think my Lord has this, that the judge divided his judgment up between period 1, which is is up to trial, and period 2, which is afterwards, because at times my learned friend muddles them up, and we have to look at the grounds of appeal and make sure we know what time we're considering. So the first 2 grounds of appeal, grounds 1 and 2, they relate to the pre-trial period, and these are the paragraphs, the issues the judge dealt with in paragraphs 50 and 51 of the judgment. And ground 1 relates to the issue of pre-tender sales pre-trial, and 51 relates to tenders or contractual sales pre-trial. And and both these all hinged on a complaint about the judge's finding that there won't be a significant price spiral. Before we get to that, just a couple of overarching points. Firstly, a reduction in the price of a product, whether caused by a price spiral or otherwise, is not enough by itself for a finding that there's unquantifiable loss. That's obviously right. The court can, in many situations, assess damages adequately, even though there's a reduction in price. And my learned friend's submissions at times go along the lines of, well, there's going to be a reduction in price, therefore loss is unquantifiable, and that doesn't follow. Secondly, and I don't know my lord has this point, damages need to be an adequate remedy, not a perfect remedy. And thirdly, whether there will be a price spiral in any particular case, as Lord Justice Floyd made clear in Interim, is a very fact-sensitive conclusion. So if we now look at paragraph 50, and this is pre-tender sales, pre-judgments, and this is ground 1, what the judge held was that he didn't think there was going to be a significant price spiral often referred to in the cases. He made the point that it was intensely fact-sensitive, and then he gave his reasons, which is that the period was short, supplies are pursuant to a limited number of contracts, and not spot sales for pharmacies. So that's why he thought there wouldn't be a price spiral. But then importantly, he goes on to say that the generics can be expected to keep records, and if Novartis succeeds in trial, those sales would have been Gilenya, and therefore there's no significant difficulty in calculating Novartis' estimated loss. And what my learned friend does is she focuses on price spirals. She doesn't engage with the judge's reasoning as to why damages on the basis of pre-tender sales, pre-trial, are quantifiable, which is that the court will know the volume of sales, and it will know what Novartis' monopoly price is, and it will know what its profit margin is, and damages are perfectly quantifiable.
Well, what's the difference between the thing the judge found, which is marked depression of price, and the thing he rejected, which is a price spiral?
Which one it keeps going, it's the severity of it, my lord, and the fact that the price spiral keeps going down and keeps going down. And the judge's finding in the third line, the second sentence of 50, is he doesn't think it's likely to be the kind of significant price spiral often referred to in the cases. And the reasons why he explained that at the short period of time.
Yeah, no, I understand. The reasons
So,
he gives, but I was just trying to understand which is, that's the point. You say that's the answer to the point that's being put against you, is the inconsistency between those, because then what's different about a significant price spiral compared with marked depression is the degree, the severity.
Yes.
Is that right?
Well, in part, yes, but the real reason why the judge found that in the pre-trial period.
I understand. He said because it was short and there were records and all that. I've got all that.
Yeah, that's our answer in relation to that one.
Okay.
So, and of course, what my learned friend then resorts to is drawing factual analogies with other cases, and we say that's obviously a hopeless approach. Then paragraph 51, and this moves on then to ground 2, and this is a pre-trial but under the framework agreements. The complaint is that the law is in relation to the judge's conclusion in the fourth and fifth lines, that there's conflicting evidence as to how much below the current Gilenya price it's likely to be, but in my view that does not matter. And again, focusing at this stage purely on pre-trial losses. The reason why the judge came to that conclusion is the next sentence, where he says there will be a clear basis on which to determine Novartis' estimated loss. And that's going back to the point about the generics will keep records, and we know what Novartis's monopoly price is, and so on.
Okay, I understand.
And so forth. So, and again, my learned friend doesn't engage with that specifically in relation to this time period in this paragraph. And we say the judge was plainly right that on the basis of that information, damages could be adequately quantifiable.
All right.
So, well, that's the pre-trial period. Then in relation to post-trial, which is grounds 3 and 4, the first complaint in ground 3 is the judge was wrong to reject Ms Bride's evidence that she thought it would be Novartis wouldn't be able to restore their prices. So we need to look at what the reasons, the judge's reasons for that were. The first one is in 52, where he makes the point halfway through that Novartis owns Sandoz, and therefore there's no rational reason why Novartis itself would ever actually lower its price. Its price would remain the same. And then in relation to in 53, the points that my Lord discussed with my learned friend, firstly that NHS commissioning bodies are sophisticated purchasers and understand the patent system. And finally, the point that my learned friend didn't highlight, but is material, which is in the last sentence of 53, is that the current monopoly price at which Gilenya is sold by Novartis has been approved by NICE. So the current decision is that price is, Gilenya at that price is cost effective. And one has to ask the question, why would the conclusion be after a period of 4 months of slightly cheaper drugs, does the conclusion become it's no longer cost effective at the price that it previously was at?
Okay.
So now none of those reasons that the judge relied upon for his conclusion as to why Novartis couldn't put the price back up, so they wouldn't lower their price, sophisticated purchasers, has previously been approved at the monopoly price. Those are unquestionably right and are not said to be incorrect by my learned friend. So we say this is one of those conclusions that the judge was perfectly entitled to come to on the evidence before him, to come to the finding of fact that on the facts of this case, Novartis would be able to resume selling at their monopoly price if they were to succeed at trial. Now, my learned friend says, well, he applied the wrong standard and he should have taken at face value Ms Bride's evidence. Now, of course, as the judge recognised in 53, he doesn't have to uncritically accept the evidence of a witness, and particularly not where, as he explained in this case, the witness isn't talking about things that happened in the past that she saw or experienced. This is speculation as to what might happen in the future. And what the judge did is, because of the reasons that he gave and those 3 factors he relied upon, he came to the conclusion that the price will be able to go up. Now, I think, my Lord, maybe we ought just, if I can briefly show my Lord the evidence that Novartis filed in support of the conclusion that they couldn't put the price up.
All right.
What the reasons were. So that's bundle C1.
I say this hearing should take an hour, but I'll listen to you, Mr. Let's go then. Where do you want to go? C1?
C1, tab 3. And it's paragraph 94. So down the bottom of page 23, I can't say for certain that this would happen. So the NHS would be extremely reluctant to pay higher prices for Gilenya.
Sorry, did you say paragraph 93?
94, C1.
94.
Sorry, NHS would be extremely reluctant to pay higher prices. Patients could be switched to other medicines where possible. Can't say for certain, but I think it's likely. This may in part be due to the reputation of Gilenya being tarnished in the period of generic availability. And also because other DMTs, although more expensive, might be viewed as providing better value for money when viewed through the lens post-generic entry. So those are the reasons why it was suggested that they couldn't put the price up. And of course, with all these things, it's not really the overall conclusion that matters, it's the reason the witness or the court gives that's the important factor. As to the first one, the judge rejected the case based on reputational damage during the period of, and that's not pursued. And as to the other DMTs, the judge dealt with this in paragraphs 55 to 50, 56 to 58 of the judgment, where he held that it was fanciful to suggest that the clinical teams treating patients who were otherwise suitable for fingolimod would move them onto a different drug merely because for a period of a number of months that drug had been a bit cheaper. Doctors prescribe drugs to patients on the basis of clinical need. And again, particularly in circumstances where fingolimod at Novartis' monopoly price has been approved by NICE as being cost effective.
All right.
So we say the judge was perfectly entitled to reject the flimsy and speculative evidence, and having analysed it critically by reference to all the evidence, to reject that. Then round 4 is hinged on the judge's finding in paragraph 61 that the overall levels of sales of Gilenya from late 2022 onwards can't accurately be predicted. But nevertheless, the reason why the judge was able to concluded that damages would be quantifiable was because my law goes to paragraph 58. Having looked at the decisions being clinical decisions and looked at some of the drugs which were alleged to be alternatives, he says at the end of 58, I see no justification for the suggestion the degree to which patients will be prescribed other DMTs will somehow be affected by whether or not fingolimod is available in generic form in the next couple of months. So that was the judge's reason for saying that. It doesn't matter if there's going to be competition, if the fingolimod market is going to shrink because there will be new and better drugs available. That's going to happen regardless of whether there's a brief period of cheaper fingolimod available. Now, my little friend says doesn't really engage with that point, and she just simply relies upon, well, it's unpredictable, therefore damages must be unquantifiable. But what is important is that there was very little evidence before the judge as to any particular competing DMT. So what we did have was the treatment algorithm, which shows that there's a defined cascade of drugs that patients are given, and not all DMTs are suitable for all patients in all circumstances of their disease. And in particular, fingolimod is indicated for those who failed on a first-line treatment or have particularly severe disease. And it's a drug to which patients are moved to from other drugs, not the other way around. And although the judge dealt with the 4 drugs that were relied upon in paragraph 58, we see Mayzent, Kempista, Ponvory, and Remitting. He notes that one of them, Mayzent, was indicated for a different aspect of the disease, so clearly wasn't an alternative. But the other 3, there was no evidence as to what those drugs were indicated for at all. So there is no evidence in the case that there is any alternative drug at the moment to which patients could be transitioned to from fingolimod, even if doctors were to haul the patient in to have a clinical assessment because they've heard that the cheaper fingolimod, the price has gone back up again, which we say is inherently implausible.
All right.
And so we say that there was ample basis for the judge to conclude that it was inherently implausible that a short period of generic competition would move patients away from fingolimod to other drugs in a way that wouldn't happen absent that competition.
Okay.
So then briefly on the balance of convenience points. Firstly, status quo. Status quo in the American Sanamid analysis is only relevant when the court considers that the balance of convenience factors are equally balanced. And of course, the judge had found damages weren't adequate remedy for Novartis, but not for the defendant. So he didn't need to consider that. But he, of course, was plainly aware of the fact that the generics weren't on the market. There's a point made about the magnitude of the damage, and the answer to that is the court needs to make sure that what it's always considering is the unquantifiable damage. What one doesn't do is look at the absolute damage and say the damage to the patentee will be very large but entirely quantifiable. The damage to the defendants much smaller but unquantifiable. But because the patentee's damage is bigger in absolute terms, that's relevant. And that of itself doesn't help. Then, in relation to the EPO, and as we say, it's not clear that the judge would have put any significant weight upon this, but he didn't mention it. But Novartis's skeleton, one of the friend's arguments, missed the point. The point wasn't that the time it took from the application for this particular patent, the grandchild divisional, to grant was due to the opposition division finding that it was anticipated because the prior art discloses the proposal for the clinical trial that ends up being claimed.
You mean examining division, but yes.
The examining division, sorry, yes.
Yeah.
But the point that was made, and the point that the judge relied upon, was that going all the way back to the original application in 2007, that was prosecuted for a number of years. And then once an adverse opinion was given, that was allowed to lapse because the child divisional had been filed. That was prosecuted, and it was only in the third go that Novartis finally put in the dosing limitation. And had they prosecuted the patents through without the divisional's lapse, they could have had a patent much sooner. And that was the point that the judge was making. And then finally, in relation to arrow relief, although of course my other friends right, my clients in trying to get some certainty in relation to fingolimod launched an action seeking an arrow relief shortly before they were sued for infringement. The point that, in relation to the balance of convenience, that we should have been seeking arrow relief much earlier wasn't one that was put.
Right.
And indeed, had it been, it wouldn't have been a good one, because we would have said, well, you had one divisional and you let that lapse, you had another divisional and you let that lapse. Why should we have any reason to believe that this time round that a patent was actually going to emerge from the EPO?
Okay.
And finally, in relation to the other points, first in relation to the Supreme Court in Neurim, as my Lord observed, there won't be time to go to the Supreme Court, and therefore it would be pointless in this case as much as in Neurim. And in any event, in the last paragraph of the judgment, the judge dealt with this point and found that whether he, if instead of adopting a step-by-step approach, he considered the overall question, he'd have come to the same conclusion. So this isn't a case where it would matter anyway.
Right.
And then finally, in relation to the point about the jurisdiction to grant injunctive relief pre-grant, that obviously doesn't arise if the appeal is otherwise rejected. So that wouldn't be a good reason for the court to waste time dealing with that point.
Okay.
So,
Thank you, Mr. Hinchley. Mr. Mitchison.
My Lord, if I can make two extremely brief additional points, and I'm sure my Lord has them already.
Right.
So it will be very brief. Firstly, in relation to paragraph 50 of the judgment, and the judge's observation that in relation to price spirals, that the question of a price spiral is an intensely fact-sensitive question. And he then went on to make findings that the period was very short, limited number of contracts. That, of course, was all supported by evidence. My learned friend, Miss May, didn't take to that evidence. But if your Lordship's note, it's paragraph 5.8 of my client's witness, Dr. Ms. Roach, which is in bundle D3, page 3.2. page 6. Indeed, the evidence that my learned friend did take you to showed that even Miss Bride, for her clients, suggested that the pre-tender period was going to expire in July of this year. So it was, even on their evidence, it was a very short period.
Right.
And as my learned friend took it on the chin before the judge, she had to say before the judge that she was saying that his findings in paragraph 50 were perverse. And that is in fact what she has to say on this appeal, because the findings he made were supported by evidence before him.
Okay.
The second point, my lord, is my learned friend, Ms May, referred a number of times on to the question of whether the monopoly price could be restored in period 2. And of course, as your lordship has already observed, there is no single price for fingolimod. It's just a group of different companies selling the product at a different price. And as my learned friend, Mr Hinchliffe, has quite rightly pointed out, in paragraph 52, the judge says that there is no reason for Novartis ever to reduce its price. So if the generics were taken off the market following trial, the NHS would only have one offeror of fingolimod. That would be Novartis, at the same price that the NHS has been content to buy the product for some 10 years since it was first approved. And of all the judges to make a finding about whether or not the NHS would buy product at the same monopoly price that has already been sold, we say that this judge was uniquely in a position uniquely experienced in the court he normally sits in to decide that there was no basis for there to be any loss of sales for Novartis or any pressure on them on price if the monopoly was restored. So
Okay.
Those two additional points, otherwise I support my own friend's submission.
Thank you, Mr Mitchison. Ms May, any brief points in reply?
Thank you, my lord. Just a couple of very short points in reply. In relation to my lord's question to my learned friend, Mr Hinchliffe, about the question of what the difference is between price depression and price spiral, his answer was one of severity. But my lord saw the evidence, which is that the pre-tender prices are going to be in the region of 50% below Gilenya price, and the tender price is going to be 95% below the Gilenya price. So that begs the question, how severe does one have to be before a price depression turns into a price spiral? And surely, on any view, 95% is good enough. And that's why we say the point of the price depression is that that's the end result of the price spiral. Whether it's 50% or 95% equally is sufficiently severe to mean that the judge's distinction in paragraph 50 frankly was perverse, and it was inconsistent and illogical, not based on the evidence, and it demonstrated an error on the part of the judge.
Okay.
The second point is in relation to the point that there would be no reason for Novartis to reduce their price. And I observed in my submissions in chief that the NHS is a sophisticated player, as the judge relied upon, but he relied upon it for a different reason than I say was the appropriate reason. As my lord will recall, I said the very point that the NHS is a sophisticated player reinforces why they're going to be in a position to want to re-enter negotiations with Novartis about price post-trial if Novartis prevail at trial.
Right.
And they're not going to walk blindly back into paying the prices that they're paying now if there's an opportunity to achieve the same for less. And I should have shown my lord that there is some evidence in the case that already, this was produced by one of the defendants, that already there are flexibilities in price between the NHS and Novartis through what are called patient access schemes. Somebody will remind me which statement it's in. And that just reinforces why we say this is not just a one-way conversation. It's in Dr. Yass's statement, which is in bundle D2, just from Edward's note.
This is
Yeah,
defendants.
D2, tab 1, and it's paragraph 28.
Right. Is that confidential? I don't know.
I don't
Someone
think so.
will blurt out these numbers.
Someone will tell me. It's a calculation that he's done based by reference to IQVIA figures.
That doesn't answer my. That's.
I don't think it's confidential. Someone
Right,
tell me
fine.
it's not. No, it's not. It's
Okay.
not. It's not.
So it doesn't seem to be talking about what you're talking about. It just seems to be saying that there's a discount.
I think the point I'm making is because there's clearly already negotiation going on between the NHS and Novartis about what the NHS pays. So to suggest that the NHS are just going to say, oh, okay then, in relation to a proposition from Novartis in the situation of the counterfactual post-trial, it is inconsistent with the judge's finding that the NHS are themselves sophisticated players in the market.
Okay.
In relation to Mr Hinchlife's submissions about paragraph 58 of the judge's judgment, we say that misses the point. The
You said you had 2 points. This sounds like the third, but let's hear it.
Yes, I'm sorry, I've got 4.
Four?
This is the third point. When I said a couple, I didn't literally mean 2. The point isn't just the impact of the generic sales in the pre-trial period on the DMT market. It's the knock-on consequence of the DMT market post-trial as well.
Okay.
And it's the fact that the market post-trial is unpredictable. And that underpins my client's case as to why damage to them is unquantifiable. The last observation is that with respect to my learned friends, there wasn't an answer to the proposition that the judge respectfully applied the wrong standard in terms of his assessment of Miss Bride's evidence at paragraph 53, which we say is one of the errors of principle of judge.
Okay. Thank you very much, Ms. May. Well, you've given me a lot to think about, and this is an important case. I will rise briefly. I will come back at 12:10. My decision.
All right.